Hi guys, this is another episode of Rappler Recap. I am Lian Wan, the Justice Reporter of Rappler, and I'm going to tell you what happened today. Today was a very big day at the Supreme Court and a very busy day for judiciary reporters. So while we were preparing for our coverage of day 3 of the anti-terror law oral arguments, Rappler got a tip that the justices who had just finished their on-bank session around lunchtime earlier had unanimously voted to dismiss the electoral protest filed against former Senator Bongbong Marcos against Vice President Leni Robredo. So we broke that tweet, and shortly after, we got a second confirmation that it was indeed unanimously dismissed, ending 4 years of litigation at the Supreme Court that cost taxpayers millions in allowances and honoraria. The Supreme Court, sitting as the Presidential Electoral Tribunal, has put an end to the electoral contest to who is the real vice president. So Vice President Leni Robredo wins that protest case at the Supreme Court. Shortly after, the Supreme Court Public Information Office confirmed the decision, and spokesperson Brian Kisosaka said that 7 justices concurred fully with the decision, while 8 justices concurred only with the result. Now, what does that mean? Concurring with the result is voting for the outcome. So if the decision says the outcome is to dismiss, you vote for the outcome, but you do not necessarily agree to the rationale or the doctrine. No other information was offered to us by the Supreme Court spokesperson, but the Marcos camp later issued a statement saying that the first and second causes of actions were the only ones junked, and the third cause of action, which is nullifying the votes in Mindanao, has not been decided by the tribunal yet. This prompted the Supreme Court Public Information Office to issue an amended briefer clarifying and putting an end once and for all to speculations. The entire electoral protest has been dismissed. The case is over in favor of Vice President Leni Robredo. Now, whether former Senator Marcos can appeal is not entirely clear at this point because we have not seen the entire resolution or the entire decision. This case ended with Justice Marvic Leonen remaining as ponente or member in charge. We can remember that Marcos, with the help of Solicitor General Jose Calida, had earnestly moved to try to inhibit Justice Leonen from this case, but he remained as the case lead even as he faces an impeachment complaint at the House of Representatives endorsed by Marcos's cousin. With that, I would say out of the way because that is still the top story. With that finished, we went on to the oral arguments of the Supreme Court, day 3 of the oral arguments on the anti-terror law. Justice Benjamin Caguioa, who we thought would not interpolate because he was skipped in the last turn, interpolated today, and we can say that he was the highlight of today's oral arguments because he spent a lot of time interpolating actually 4 counsels of petitioners, and he questioned the broad powers of the Anti-Terror Council under the anti-terror law. And I will just recap what he said to you. Let me just get my notes so I don't get this wrong. So first, Justice Caguioa focused on the power of the Anti-Terror Council to issue an arrest, to authorize the law enforcement to arrest somebody it suspects of being a terrorist. Now, Justice Caguioa was saying, under the Constitution and under decisions that have been decided by the Supreme Court, they all say the same thing. Warrants of arrest are a power of only the judge or the court. That is a well-settled doctrine. And so he's saying that if the Anti-Terror Council has the power to authorize law enforcement to effect an arrest, that is essentially a warrant. And the Constitution is very clear that only courts and judges can issue a warrant. So he's saying if it walks like a duck and talks like a duck, then it must be a duck. And we are in a situation where there is a question on the separation of powers between the judiciary and the executive. And to that, UP Professor John Muller replied, well, that is what we've been saying all along in our petition, is that this odious provision gives a judiciary power to the executive. After that, Justice Caguioa moved on to the point of designation. What is designation? Under Section 25, the Anti-Terror Council can designate a person or a group as being terrorist without a court trial. So this designation power is distinct from the power of prescription. Prescription goes through a court trial. Justice Caguio was saying, if I want to declare somebody as a terrorist, the government would not have to go through the tedious process of prescription. I could just designate them because I have that power. And they're the same. And Professor Molo said, well, in fact, they're the same. That's what we've been saying. In my earlier interviews with the DOJ and in earlier manifestations of the government, they're saying that designation is only for the purposes of arrest. When I designate you, I'm just gonna freeze your assets. But to Justice Caguioa, it doesn't really make a difference. Designation is not really that much different from prescription. He said, and to quote him, he said that, to quote him, it seems to me designation already achieves the purpose of prescription. So that's what he said, and Professor Molo agreed. And Justice Caguioa did not only question the validity of sections 29 and 25, section 29 being the arrest power, he also made the case that the question of the legality of section 29 already is a question of law that falls within the judicial review of the Supreme Court. So he's trying to say that this provision alone is a justiciable controversy that is ripe for adjudication of the Supreme Court. This addresses previous concerns that the petitions are actually not ripe yet for the Supreme Court's adjudication. Justice Caguioa seems to disagree, and he's saying that Section 29 alone is enough for the Supreme Court to take judicial review. After that, Justice Caguioa moved on to the burden of proof. So ordinarily, in a court trial, the prosecution has the burden of proof to prove that the suspect is guilty. The petitioners are saying in the anti-terror law, the burden of proof has actually shifted. So the suspect has now the burden to prove that he's innocent. Justice Caguioa seems to agree also with this because he's saying that if I am caught by a law enforcement officer and he says that I'm detaining you because I suspect you of being a terrorist, my second recourse would be to file for a petition of habeas corpus, which is an extraordinary remedy against illegal detention. And when I file that, my lawyer would have to tell the court why I am innocent. So to that effect, Justice Caguioa is saying that the burden of proof has shifted from the prosecution to the suspect. Finally, Justice Caguioa discussed the threats made by Military General Antonio Parlade, who's also the spokesperson of the NTF-ELCAC. If you remember, in a Facebook post, General Parlade threatened the petitioners of the anti-terror law, and to quote him, the general said, "Very soon, blood debts will be settled and the long arm of the law will catch up on you and your supporters." Justice Caguioa happened to read a Manila Times article where General Parlade said he made a mistake in threatening the petitioner. And Justice Caguioa said that if General Parlade is admitting that he made an error, then that must mean that the anti-terror law is vague, because if it's not vague, then he should not have made the mistake in the first place. So that again agrees and falls on the side of the petitioners. Day 3 ended past 5:30 p.m. It ended quite interestingly because before they ended, Albay First District Representative Edsel Lagman went to the rostrum and asked if he could make a manifestation. And he was allowed to. And he said that never before has a petitioner before this court been threatened of prosecution by a military general, referring to General Parlade. And he said never before has a petitioner been taken into custody by law enforcement. He's talking about UP graduate Chad Book. He's a volunteer teacher at a Lumad school in Cebu City. He was one of the 26 people arrested yesterday in a raid in USC, which the police is claiming to be a rescue. And Chad, along with 6 other adults in that group, have been threatened by the police to be sued under the International Humanitarian Law and the Special Act on Children in Conflict, both war statutes. And Congressman Lagman was saying that never before has this happened to our petitioners. So he pressed the Supreme Court to issue finally the temporary restraining order, the TRO, or any injunctive relief to stop the implementation of the law, at least temporarily, because the law has been in effect for 7 months. Chief Justice Diosdado Peralta asked him to submit that motion in a written request, and they will make Solicitor General Jose Calida to answer it once more. Effectively, the manifestation resulted in a redeliberation of the request for TRO. So Justice Hernando was saying all the pleadings must be in by Monday noontime so the justices can deliberate on it on Tuesday. So we're expecting that on Tuesday, next week, February 23, the petitioners will be finished. Justice Javier was the last one to interpolate earlier. And we are expecting for Solicitor General Jose Calida to take the rostrum and take the grilling, this time from the justices. We're also expecting the amicus curiae, retired Justice Francis Hardaleza, to present his position. And the Supreme Court has also appointed retired Chief Justice Reynato Puno as another amicus curiae. It's not clear yet whether he will orally present his position before the Supreme Court. We're also asking that. So that's what happened on day 3. Day 4 is on February 23. If you need refreshers of what happened, we have a live updates page on Rappler.com, and we are going to be repushing all our stories on Twitter and Facebook. Once again, thanks for listening to this Rappler recap. I hope I kind of made it digestible for you. Thanks again, and have a good evening.